Great. Okay, we are live now. Okay, good evening, everyone. Today we will talk about the roles of defense team in the International Criminal Court. We are hosting today Counsel Cyril Lauchi and Mr. Ahmed Isa. Counsel Cyril Lauchi is a French lawyer with an extensive experience in international criminal law. He has previously worked at the ICTR, Special Court of Sierra Leone, and different sections of the ICC. Counsel Lauchi is currently the lead counsel in the defense team of Mr. Ali Muhammad Ali Abdurrahman in situation of Darfur, Sudan. Also, Mr. Ahmed Isa is currently the case manager in the same defense team at the ICC. Ahmed has acquired experience on both the national and international scale, most notably with previous experience at the victim participation and at the reparation section of the ICC and the victim participation section of the Special Tribunal for Lebanon. Good evening, Counsel Lauchi. Good evening, Mr. Isa.
Good evening.
Good evening, Nazim. It's nice to meet you.
It's a pleasure to be here. Thank you for having us.
Thank you. Let me first introduce our initiative. IHL and Law Students is a volunteer initiative established in 2018 on non-profit social media sites that was occurred to develop the legal skills of students and researchers in three branches of international law, namely international humanitarian law, international human rights law, and international criminal law, by providing wide open spaces to enhance the legal culture of students and researchers looking to work within the international community by opening the door for members of the group to communicate with experts in the above-mentioned branches. So, if you let me, Mr. Lauchi and Mr. Isa, to start with our questions.
Sure.
My first question is, could you please give me an overview of the offices of the ICC and their types?
Well, thank you. Thank you for inviting me tonight first, and welcome to the audience. Even though I cannot see the audience, I am very pleased to speak with you tonight, and also with Ahmad. the basic structure of the International Criminal Court, I understand that this is the question that you are asking. Well, it's composed of various organs. First of all, you need to remember that the International Criminal Court is, first of all, an international organization, which is very important to understand what it is in the context of international relation and international law. Within that international organization, which is a judicial organization, this is a very specific type of organization. You have various organs, which are all organized by, of course, the treaty that has established the International Criminal Code, that is what we call usually the Rome Statute of 1998. And these organs are the judiciary, which includes, actually, it's a two-head organ, because you have on one side the presidency of the court, and then you have the judiciary, which is composed of chambers, that is composed of the 18 judges. The presidency is composed of 3 judges elected among the 18, and the other 15, and actually 18, because presidency are both in presidency and chambers, you have all the judges together. That's the first organ. The second organ, which is very famous, is the Office of the Prosecutor, because the Office of the Prosecutor is the one feeding the court with cases when they reach a point in their investigations where they believe they have a case for which the court may have jurisdiction, for which the court may be competent. Then they will bring a new case and request a warrant of arrest for one specific person in one situation. So that's the Office of the Prosecutor. It's famous because that's the organ in charge of triggering proceedings before the International Criminal Court. One organ which is less famous, but which is key, which is extremely important, is the Registry. The Registry is actually twofold. It's one, the organ in charge of the administration of this international organization, and then the Registry is really in charge of dealing with all aspects which are the aspects of the court related to its functioning as an international organization. Think about recruitment, human resources, think about budget, think about international relations, security, taking care of the premises and all that sort of things. That's for the Registry, that's the administrative part. And the Registry is also playing a role in the judicial proceedings, which is what we call the court services, which is playing the role of a registrar, the same way as you have registrars in the domestic courts. Registrars, well, their role vary from one country to the other. They can be described as secretaries to judges, but in the ICC they are much more, because the Registry is in charge, for instance, of detention, of the protection of witnesses and victims, of dealing with victims' participants, and dealing with also us, the defense counsel. So it's a very important organ. These are the 3 main organs. You have other offices which are less important and which are most often working under the umbrella of another organ, particularly the Registry. But I will stop there and not delve into more details. That's the basic structure. It is the same for the previous tribunals, the international tribunals, ad hoc tribunals for former Yugoslavia, Rwanda, Lebanon, etc. The same structure made of 3 organs, well, with this presidency on top of the chambers.
Thank you, Mr. Lauci.
Do you want to add something?
Mr. Counsel Lauci represented quite perfectly this representation of the different organs of the court, so I have nothing to add to this.
Thank you, Mr. Isa. My second question is, could you please tell me about, let's say, could you please talk about the roles of the defense in the tribunals, or let's say in the trials of the ICC?
I think there are various ways of defining the role of the defense, and that's also because there are different defendants and different counsel, and it's what is important is for each person, each suspect or each accused to find and identify the counsel that fits his purpose. Essentially, I have said that the office of the prosecutor is the organ triggering the cases because he is the one investigating and then bringing the charges and then prosecuting the person in front of the judges. And this is a kind of extremely dramatic situation at the beginning where you have this person, most often it's only one person, sometimes you have multiple accused cases, but it's one person alone facing this whole machinery, the whole office of the prosecutor, the whole international organization, the whole registry, etc., etc. And it's very one person against basically the world, because also keep in mind that in a way the International Criminal Court is meant to represent the international public order, and that is the interest of prosecuting international crimes of concern for the entire humanity. So, and in front of this whole thing, you have one person, and this one person, the key element to understand what the defense is to remember that this person is presumed innocent. The person is accused, there are charges, could be witnesses, could be evidence against that person, but the person is presumed innocent. What does that mean? I remember just an anecdote. In the case of Mr. Ali Muhammad Ali Abdelrahman, we made the initial appearance on 15 June 2020, and when we walked out of the premises of the court, there were some Sudanese journalists, and they wanted to have an interview. And the first question they asked, I mean, I think that must have been the first interview they were making in the context of the International Criminal Court. They asked me whether Mr. Abdelrahman was guilty. And the only answer that I could make to that is, well, at this stage, Mr. Abdelrahman is presumed innocent. And what does that mean? It means that the probability that he is guilty on this day, at this corner, where we have no evidence yet, because it's the very beginning, initial appearance, the prosecutor had not started yet to disclose its evidence, of course. So the probability that he is guilty today is the same that I am or that you are guilty. The same. And then I think it's very important to measure the importance of the defense, because anyone could be charged one day with an accusation that he committed a crime. I hope not an international crime of war crime against humanity for everybody. I wish that to nobody really, but that could happen. I mean, mundane crime, you are accused of having stolen something or maybe killed, I don't know. That could happen to anyone. And at this stage, you will be the one person alone against the world, against the whole machinery. And the defense comes at this moment in time to stand just next to the person. And which makes that the person is no longer alone, but there are now two persons, or one plus one person and the team. I'm extremely lucky to have a very excellent defense team, including Ahmad here. So, which we are here to stand by this person and make sure that the person will be tried fairly, that his right as a defendant will be respected, that all the requirements for a fair trial are there, and that the person cannot be found guilty and sentenced without a proper trial. And this is really the role of the defense. That's the key. After that, you could ask, how do you achieve that? And this is where the means can vary. I have seen, you mentioned that I worked in various tribunals, not in defense, actually. I've worked for chambers, registry, and everything. But I have seen many kind of defenses, totally different. Some people will have a defense that is focused on really the procedural things and making sure that everything is respected and everything. You may have political defenses. You may have defenses that will say, we deny everything, we did not do, nothing happened. There was no crime committed. You may have defense, well, it really varies, and this is where the free choice by the suspects of his defendant is important, because he needs to really, the two of them really need to match and to be on the same line. That's very important. After that, yes, of course, the role of the defense is yes, to be the watchman of the proceedings, to make sure that all these powers, the prosecutor, the judges, and everything do not miss anything about any aspect of the due process rights, fair trial rights. That's very important, and it's a role that is, of course, sometimes not pleasant for the institution, not pleasant for the judges, not pleasant for the prosecutor, because it's the role of the defense to say when something is going wrong. But the right question is, if nobody tells you that you are doing something wrong, how can you do it right?
No, I fully agree with Counsel Lauchi's input. Indeed, any person deserves a fair and impartial trial, and having an efficient defense team is essential to allow that. In relation to the role of the defense, I often get asked by people, how can you defend a criminal, or how can you be on the side of the bad guy? First of all, as Counsel Lauchi just mentioned right now, he is not a bad guy until proven to be guilty. The role of the defense is, in reality, finding the truth as much as the office of the prosecutor, to make sure that justice is served correctly by conducting its own investigation, by reviewing evidence disclosed by the OTP, and whether it proves or not, beyond reasonable doubt, the guilt of the accused. Also, there is a common misunderstanding for many when referring to the defense. The defense is not about saying blindly that a person is innocent, and its role is not limited to the innocence of the accused. It's to make sure that the person's international human rights law and the ones mentioned, for example, in Article 67 of the Rome Statute are respected. This starts from the very beginning, and it includes any types of rights, including the conditions in which the person was arrested, for example, or the ones or how he's, like, when he surrendered, and the conditions of the transfer to the court, also the conditions in which he's detained and other types. So the defense also checks for many things like mitigating circumstances, such as the case where the accused was unable to act freely or with full consent, for example. These are cases that the defense takes into consideration. Or also if they were able to provide an alibi that proves that a person was not at the same place at the time of the commitment of the act. This also could be taken into consideration by the defense while providing arguments to the chambers, etc. The defense is also a really important party, so they may file arguments that may and usually does affect a decision delivered by the chambers, which is a contribution in a way to the path of justice. So in many cases also, like the innocence of the person is not even in question. So take, for example, the Al-Mahdi case, where the accused pleaded guilty. they went straight away to sentencing without going even into the trial phase. So in that case, obviously, the role of the defense won't be related to the innocence or guilt of the person, but was rather to assure that the person receives a fair sentence. But
Ahmad, we cannot hear you.
Ahmed, there is no voice.
Ahmad.
freedom is the rule. Yes. Yes. Do you hear me?
We could not hear you for a moment.
Oh,
we can hear you now. It's okay. We can hear you now.
I was talking about that the innocence of a person is usually not in the question itself. The last thing I was talking about is the Al-Mahdi case, in which the accused pleaded guilty, so they went straight away to sentencing. And in that case, you would not really need to check the innocence or the guilt of the person. You would want to make sure that this person receives a fair sentence, or study all the circumstances that would diminish the sentence based on certain facts or the charges themselves. But let's say the person is actually innocent, and the person was declared by the judges to be innocent. Then the defense has achieved the freedom of a person. And at the end of the day, freedom is the rule, and the deprivation of freedom or prison is the exception. So like there are many cases, such as the Bemba case or the Bagbo case, where the accused was detained for more than 8 years. Then he was declared as innocent. These are years these people won't take back. So at the end of the day, the purpose of the court is justice, regardless of to who. Of course, essentially for victims. But I've personally worked on the side of victims for a while before joining the defense side. And believe me, there's no bigger injustice for victims than sentencing the wrong person for acts that were truly caused by another. Yes.
And because this other one will remain unpunished, whereas an innocent one is punished.
Of course, as Ahmed mentioned, the main purpose for the court, for the attorneys, for the defense team, is to spread justice around the world. And at the end, if there's someone who was accused with crimes he didn't really done, at the end he became at this situation a victim also.
Indeed.
Just
it is the case of many, not necessarily in international criminal law specifically, but also in local law. You have many people who are actually criminals, but also victims at the same time, victims of a certain society, victims of things that push them into making crimes. So the defense side needs to take into consideration all elements, not just the fact that a person has committed a crime. The defense takes into consideration why they committed these crimes, the mitigating circumstances, or as called in French, circonstances atténuantes. I'm not sure if it's precisely mitigating circumstances, but yes, this could give a bigger perspective of the side of the defense.
Thank you, Ahmed. Mentioning Rome Statute, what are the procedures that Rome Statute grants to the defendant?
Well, of course, there are. I could speak for hours to answer these questions. Ahmad already mentioned a lot of aspects. Well, in the ICC, you have 3 essential phases. The first phase that we call the pretrial stage, this is where we are now in our case, is the case that runs from the transfer of the person, whether the person was arrested or surrendered, but the transfer of the person to the court, the initial appearance, until the confirmation of the charges. which comes after a hearing, which is called the confirmation hearing, before a pretrial chamber. This phase of the case is more or less a phase of preparation. This is where the court will determine whether there is sufficient elements to bring the person to trial. In this phase, the role of the defense, actually, I speak for, it's my opinion, and that's the way we do it, is because it's a preparatory phase, it's to make sure that all the requirements for a fair trial are there, all the basic requirements. It's making sure that the court is competent to prosecute the person, to make sure that, because the ICC is working under this system of when a national court is prosecuting a crime, then the court cannot. That's the question of admissibility. So is the case admissible? Does the court have competence? Whether did the prosecutor discharge its function of disclosing evidence in times for the defense to prepare? All these questions. And concretely, what is, I mean, you have all the articles. Ahmad mentioned the Article 67, which is key. I mean, that's the essential article for the rights of the defense, but there are many others. How is this done? This is done by making submissions before the judge, before the chamber. You submit, you make motions, you make requests. When you identify something that is not clear or not right, you raise it, you or ask for this problem to be resolved and everything. So that's what we do on a daily basis. Actually, in the pretrial phase, we do two things on a daily basis. We write submissions to make sure, once again, that all these requirements are there, and we review the evidence disclosed by the prosecutor in preparation of the case to understand what is the case of the prosecutor and what are the exact nature of the charges that will be brought, because we do not even have the list of charges at this today. But we try to see whether the charges that will be brought are supported by evidence. That's the pretrial phase. Then we proceed to trial. Between the confirmation of charges, if they are confirmed, because sometimes the charges are not confirmed and the proceedings stop there. This happened in many cases, including the other one of the other Sudan case, the case of Abu Ghara. So if the charges are confirmed, the case will proceed to trial. In between, there is a period of time, which is the preparation of the trial, and then we start. And the trial means that the chamber and the parties will be in the courtroom and will go through the evidence. We'll consider the evidence of the prosecution first. The witness will appear. There will be examination, cross-examination. There will be documentary evidence disclosed and everything put on record and discussed. This is when we challenge the evidence. Then that will be the evidence of the defense, because the defense, of course, also has the right to present evidence. In order to present evidence, the defense can, one, proceed with its own investigation. The means that are allowed to the defense to investigate a case are extremely limited when we talk about material means, including financial means to go on the field and to investigate and everything. But also the prosecutor is in charge of disclosing evidence that would be in favor of the accused. And that evidence, the defense after that needs to decide whether this is actually material and whether this serves the defense the way it is presented. There will be also, in the process of the trial, an opportunity for the victims also to present their views and concerns. The the modalities of that can vary from one case to the other, because each chamber will decide what are the prerogatives that it will give to each party and participant, including the victims. Then at the end of the trial, of course, the chamber will deliberate and issue a judgment. And then whatever the judgment, can be a conviction, can be an acquittal, but then there will be finally the last phase, which is the phase of the appeal, which can be initiated by the convicted person, if the person is convicted, or by the prosecutor, who can also appeal an acquittal. The last phase that comes after that, or somewhere in between, it's not very clear in the practice of the court yet, is the reparation phase for victims, which is also a very important one. We have made, in the Abdelrahman case, we have made in July 2020, we have made proposal for really innovative proposal to have the reparation phase start from the beginning, because we submitted that the reparation should not be conditioned by the conviction of the defendant. And even if the defendant, Mr. Abdelrahman, is found not guilty and acquitted, or the charges are not confirmed, this should not mean that the victims cannot receive reparations. The harm for the victims remains the same. And there is this conditioning the reparation for victims to the conviction of the person is just a nonsense. We made proposals. At this stage, the proposals have been rejected. Fine, fair enough. It doesn't mean that we will not come back at some point with the same or slightly differently presented propositions. And in any way, even if in the case of Mr. Abdelrahman, these proposals will not succeed, we will carry on supporting them, because there is a strong belief that this is the right way for reparation for victims, and this is the only way actually the court will actually discharge its mandate toward victims, which is key to the success of the court. So for the court and for the victims, we will carry on supporting these proposals.
Thank you, Mr. Lauchi. Mr. Ahmed, would you like to add anything?
I think that Counsel Lauchi pretty much emphasized on all the proceedings and all the stages in which the accused or the Rome Statute talks about, in terms of all stages: the pretrial stage, the trial stage, the appeals, also sentencing. And he also emphasized on the importance of importance the statute gives to the disclosure of evidence, also the rules of evidence of procedures in terms of disclosing exculpatory material or material under Rule 77 and incriminating documents. So I would just like to reconfirm my personal high interest in the reparations diversion or creativity that Counsel Lauchi presented to the court. Obviously, the role of the defense is not creating something new, giving a new idea that may provide a new way of looking at the rules. Sometimes, even when a certain practice was with time based on certain elements, it does not mean that this practice cannot change. So the Rome Statute, while it is the base and the rules of evidence of procedures complemented, there's also always room for improvement with jurisprudence and new propositions with the councils, obviously.
But just one word. This is also an illustration, a concrete illustration of what I said earlier about the need for the suspect and the counsel to match. You may have persons who are accused who say, I don't want to hear about the victims. They are all bloody liars. Don't tell me about them. They should be rejected. Go to hell. And of course, they will never say that bluntly, but that could be the general idea. in this case, we had an accused who was totally different, and from the day of the initial appearance, his first request was to have a minute of silence in memory of the victims in Sudan. So, of course, this is where he and I could match, and with this idea of a new proceedings for reparations and everything, and promoting that. And showing that the interest of the defense and the interest of the victims are not necessarily opposed and can to some extent, sometimes converge, was something that we could do because we were exactly on the same line. The suspects, Mr. Abdelrahman and myself. This is an important element to show you how different can be the defense, the lines of defense and the defense strategies and the conception of how this could work.
Thank you, Mr. Lauchi. I have another question. Are defense attorneys independent or affiliated to the court?
Before the International Criminal Court, defense lawyers are independent, and it's not just a rule, it's an absolute obligation. We are working under a code of conduct for counsel, and the code of conduct for counsel makes clear that we not only are independent, but we have an active duty to defend that independence from any interference. So that's a very strong one. In some other international courts, they explored alternative ways, like having a defense office, which was the first experience of defense office was before the Special Court for Sierra Leone, and then you had one before the Tribunal for Lebanon. But even with that, even though the defense office was the central office composed of people who were staff members of the court, so employed by the court and working as international civil servants, not as external independent counsel, but with an independence that was organized within the terms of reference of the persons. So this experience was made. I cannot say if in the future we will have that again, but even when there were defense office, these defense office were working together with independent counsel. So it's not because you had a defense office that you no longer had external counsel. They were in charge of certain aspects, for instance, defending the general interest of the defense, for instance, which makes sense because, as I said, ICT is an international organization. It has a whole administration. The administration has to take some decisions, like, for instance, budget. Every year we write the budget. What are the costs that are attached to each function of the court, right? Okay, if you have a defense office that can have a word in this administrative process and make sure that the needs of the defense are taken into account in the preparation of the budget, of course, that makes sense. And this is a function that no external counsel like me can do because we are focused on our case and we have no stand to participate into the administration of the court, whereas an independent office within the court can be in a position to play that role. I'm taking the example of the budget, but that can be many other aspects. In the ICC, we have currently the Office of the Public Counsel for the Defense, which is a sort of defense office, which has sometimes been called to play this role of defending the general interest of the defense. Not so often. It has been called to sometimes to play the role of a lead counsel, usually for a very short period of time, and when there was no possibility to appoint the counsel of the defendant's choice, especially when the defendants were not transferred to the court yet, and so we could not have the input of the defendant as to which counsel he or she wanted to have. And generally, the Office of the Public Counsel for the Defense, the main function of the Office of the Public Counsel for the Defense is to provide support to the defense team. So we receive support on a daily basis from the Office of the Public Counsel for the Defense. Ahmad, the case manager, can say more than me actually on that, because on technical aspects and everything, I think OPCD is quite useful. They can also make some legal research sometimes if we need it, because we have a small team and they can provide assistance. So, but Ahmad, maybe you can say more about that.
Definitely, OPCD usually, while they represent the defendant, even sometimes, like let's say the Sudanese case, at a certain point where victims' matters were raised in the past, and the defendants did not used to have a defense attorney. They used to appoint the Office of the Public Counsel for the Defense, who used to take certain stands. And once he takes certain stands, they always mention within their filings that whenever a lead counsel would be appointed, he would later on, he is allowed to review these documents to change his opinion. So the Office of the Public Counsel is usually used as an alternative in certain cases when it is needed, or for a temporary short of time, as a short amount of time, as Counsel Lauchi has mentioned. In relation to the technical stuff, indeed, the Office of the Public Counsel for the Defense can assist in terms of legal research, but also the technical stuff could be many things, such as certain systems, let's say, that were dealt with in the past. Take, for example, Case Map, a system that a new team comes in, they're not familiar with it, so the Office of the Public Counsel for the Defense has the expertise and the experience in previous cases on how they dealt with, let's say, Ringtail or Case Map or different systems that defense teams usually use. So generally speaking, the OPCD is a public Office of the Public Counsel, so they consult, the councils consult it, and they can provide it with input on how to use these systems, how to they might have jurisprudence that would be relevant as well for the defense. So they are very reliable, I would say.
And generally speaking, the Office of the OPCD is actually the right solution if we want to have the voice of the defense better heard and taken into account into the management and the administration of the court. So this is something that each individual counsel should support strongly.
Indeed. Also, on this same topic, regarding the independence of the attorneys, the defense attorneys, or their affiliation, I'm mostly focusing here on their affiliation with the court. As Counsel Lauchi mentioned, in terms of them being externals, or as the defense is not actually an organ of the court, they are external staff of the court. And therefore, despite that, they are still a very important party in the proceedings. And unfortunately, the fact that they are not an organ of the court and the way the court is dealing with it sometimes is impacting negatively on their role. So the accused does not only have a right for the defense, for a defense, but he or she has a right for an efficient defense. And this is a principle that was accepted or followed by different international principles and international courts, such as the European Court of Human Rights and both the Inter-American Court and Inter-American Commission of Human Rights, where the counsel is, where the defendant has a right for an efficient defense. And if you do not provide the defense with what it would require to do its work efficiently, then you are violating the rights of the accused. We see so many redactions and so many ex parte filings, and the fact that you are hiding from the defense or dealing with it as an outsider, like the defense is outside of the procedures, this impacts justice and the fair trial, since it impacts the efficiency of the defense. I believe that these are gaps that the court needs to improve and to find a way to involve the defense more in its work, as it's a very important party in the proceedings.
And your PCD can play a role in precisely this internal debate to make those reforms or others that Ahmad is suggesting.
Thank you. My next question is, what was the impact of COVID-19 on the work of the defense team?
I would make a distinction here. I mean, COVID is, we can all get the coronavirus. That can happen, and for that, I hope, I wish you not to get it, and if that happens, I wish you to recover quickly. So that is a potential impact that is bearing on actually any human being, be it in the defense team or in the office of the prosecutor or anywhere else. So we are all equal before the disease right now. What the distinction I wanted to make is that very often we read in submissions before the court or in decisions even that the COVID also has an impact on the procedure, on the proceedings, because, for instance, the restrictions to travel would impact on the capacity of the office of the prosecutor to investigate, or the capacity of I don't know, to protect witnesses or whatever. It's not something that should be accepted, really, because it has no merit. You know, the court is an international organization. As such, it enjoys privileges and immunities, and the privileges and immunities are provided in the Rome Statute itself, but are also provided in the agreement on the privileges and immunities of the court and the host state agreements. And all these provisions all provide that the staff members of the court, or the council even, shall not be subject to travel limitations. There is no caveat for COVID, which means that we can, if we need for the purpose of our investigation to go somewhere, we go somewhere. And there is no travel restriction that can apply and prevent us from doing so. So this is an argument which is a little bit too easy, and that we find very often. I would really invite everybody to refrain from abusing these arguments, because the right of the defendants to be tried without delay shall not be impacted by the circumstances of the COVID-19, really.
I fully second that. Also, we've seen the impact of COVID-19 in different cases. Like, for example, we can take the submissions of the defense of the Al-Hassan, Mr. Al-Hassan. In the Al-Hassan case, the defense filed for an interim release on the basis, many different, using many different arguments, but one of the arguments was the fact that COVID-19 causes a risk on certain detainees, and this would potentially lead to their interim release. Of course, this was not accepted by the judges. However, it does show us that it is seen as a risk. It is taken into consideration at a certain point by the defense of a person, and also the detention center always has this, as the defense, we are concerned with the protection of the health as well of the accused. So we need to make sure that this does not occur, and therefore it is our duty to make sure that the measures are always on point. The detention has been doing a good job so far, but it is the defense's role to supervise also the health of the accused.
Yeah,
but also,
yeah.
Sorry.
You're absolutely right, Ahmad, to mention detention in response to this question on COVID-19. There are European recommendations and guidelines on how to deal with the risk of COVID-19 in detention. We can question how much, if at all, these recommendations have been taken into consideration by the court. But I think this is an ongoing debate, and it's not over. So we'll see what are the concrete measures taken.
Yes, but also the impact of COVID is not necessarily only linked on the like the filings and all these things, but also on the efficiency of the team itself. I am currently going to the court and working from the office, but I always prefer being surrounded by people where I can share knowledge, and I feel more comfortable having the whole team surrounded me. And the thing is, this is not currently possible with COVID, because you would feel more efficient working in a workplace surrounded by your team. It would be faster also in terms of sharing knowledge. So while this is not directly, it could impact us indirectly in a very small way, but it does have, in a way, that kind of impact. So, yeah.
But with the number of communications we have on a daily basis, this impact is...
That is true. That is true. And hopefully this situation will be over with the improvement with the vaccine, the situation of the vaccine, and maybe when things go back to normal, everything would advance, and also this impact would reduce in all ways.
Thank you, and we hope this pandemic goes and so we can go back to our normal lives. We can, as we all know, in-person interactions and with the people is way different than online dealing with persons. Last but not least, counsel assistants and how to become one of them. Could you please, Counsel Lauchi, talk about this topic?
Maybe Ahmed can.
Can I? I would like to answer this question.
That would be great.
Yeah. Usually, I mean, any application to the ICC is usually done on the website of the court throughout using the vacancies and the job vacancies. However, when it comes to external staff, this is not applicable. Usually, the first thing you do when there is an accused in custody, he is the one who appoints counsel, and it is up to the responsibility of the counsel to create his own team. This is how it usually goes. Now, in most cases, he or she hires people who they are familiar with their work, the quality of their work, people who are qualified usually, and they know about them. That's the most practical case. But in case these people are not available, they sometimes post vacancies on public websites, social media. When our team requested resources, for example, the ICCBA posted it on their social media account on Twitter and LinkedIn. These positions would not be posted on the ICC website, unfortunately. There's also a list of legal assistants on the court's website where people can apply to enter the list to be admitted. However, you need a minimum of years of experience and other qualifications, like an advanced degree, for example, in law and in international law, probably. This is simply to be on the list. Counsel may consult, like the counsels may consult this list when looking for candidates. So the OPC also usually is familiar with certain profiles. They may provide counsel when appointing, when they want to appoint somebody. So that is usually the best way to become an assistant to counsel. There is no direct way on the website or clear up. There's not one way for sure.
But what the people should do, the people who are eligible, which means that they have reached the 5 years of professional experience, either in criminal proceedings or relevant domain of international law or procedure, they shall apply and ask to, no, it's not apply to a specific position, but apply for admission on the list of assistants to counsel, which is managed by the registry. Once again, the counsel support section. All the information is available on the website. This is Rule 124, 125 of the regulations of the registry, and you have the full explanation. And once you are registered on the list, then one counsel can appoint you, or you can go and see a counsel. And the chance we have in defense precisely is because we are independent. We are also totally free in terms of the way we select and appoint people. The only requirement is that the people shall have the requirements, shall be registered on the list, and then we can proceed very easily. And that's a recruitment that is done at the level of the team without intervention of the court's human resources whatsoever. So whereas, and I can tell you for having gone through this, the recruitment processes for international organizations like the court can take years. For the defense team, this can be done very quickly under the condition that you are already on the list.
Mr. Ahmed, you have mentioned ICCBA, the International Criminal Court Bar Association. Could you please define the ICCBA or talk briefly about it, please?
I think Counsel Lauchi has more experience in terms of dealing with the ICCBA, or yes,
well,
his past experience with the ICCBA.
Yeah.
Could you please tell us also how to get enrolled in it?
Yes, actually, I might say that because I happen to be an elected member of the Executive Council of the ICCBA for the first 3 years of its existence, and also the chair of the Legal Advisory Committee of the ICCBA. And I'm still a member. The ICCBA, well, is a relatively new initiative that is really an independent initiative that has been taken by counsel. And when I say counsel, don't limit your thoughts to counsel for the defense. It's a common initiative of counsel acting on the side of the defense and counsel acting on the side of victims, that is legal representatives of victims. Actually, normally a counsel can work on either side as long as he feels ready for that. I would be totally ready to work on the victim side once I'm done with this case for Mr. Abraham. That can happen, future will say. But so it's a common initiative to create a body representative of counsel. Because in the rules of procedure and evidence of the court, you have this reference to the representative body of counsel, which has a role to play precisely in the consultation with the management and the administration of the court on how to better improve the service that is provided to counsel. But this body did not exist. So this was created, and it is now in existence, representing a lot of counsel who are on the list, who can vote, and every year to renew the various committees, including the Executive Council. And well, this was created in the form of an association under the Dutch law. But yes, this is the official representative body of council. It has been recognized as such by the Assembly of State Parties, which means that every year the ICCBA can speak before the General Assembly of of state parties to make representation on behalf of counsel, both, once again, counsel for victims and counsel for defense.
Thank you, Mr. Lauchi. My next question is
I forgot something about the ICCBA. It's not only counsel; it's also the support staff. That is the legal assistants about which you asked the previous questions, who can also become member of the ICCBA.
Thank you, Counsel Lauchi. My next question is to Mr. Ahmed, is how to apply for internships with the ICC.
To apply to an internship, usually internships are posted on the website of the court. So you can simply go to the website. There's a section for vacancies. Usually it's divided. There's the section for the jobs, the normal positions, and also the section for the internships. For the internships, it depends by section. Each section has its own internship. So you would see a vacancy for an internship with, let's say, VPRS in the registry, the legal office in the registry, or in the office of the prosecutor. To be able to apply to an internship for the defense or the LRV, for example, there is a specific internship opening called Internship for External Teams. So this would allow them to be able to apply to internships for the defense. Usually the procedure would require many documents. I assume they would have the grades, the transcripts, also a recommendation letter from different people. Possibly one of them should be academic. Also, they would require a motivational letter, an essay where they can test their writing skills, and all documents that can support their degrees, everything. However, nowadays, internships, precisely at the ICC, have become a little bit less accessible because of the COVID. Interns are not allowed to be recruited from outside duty station. So if a person lives outside the Netherlands, it will not be possible for them at the moment with the COVID-19 situation to apply to the ICC, unfortunately. Hopefully after the COVID, this problem will go and people will be able to be recruited again from outside. Remote internships have not been yet available for the ICC. Other organizations are offering them, including the UN. They opened many remote internships. That's basically the procedure. I would, in my perspective, an internship could provide a lot of knowledge for people. I would highly recommend young, talented or academics who have done research, etc., to put this knowledge into practice and to start working on being able to have an internship, because they would be able to work with highly skilled people and highly experienced professionals, and it's an excellent way to work in a multicultural environment. So it is a great opportunity. The only negative, however, in that sense would be the fact that internships at the ICC are still not funded, not only at the ICC, also most of the UN, they are not funded. So if a person can't bear the cost of these internships, they will find it a bit hard to get in, basically, which is unfair for those who can't afford the living costs, etc. Because many people would have the qualifications, but just for financial reasons can't take it. This is unfortunate. Hopefully, with time, the UN, the ICC would start providing more funded internships for people who would be interested in taking such an opportunity.
Thank you, Mr. Ahmed. My last question, let's start with
I just want to add a word about the importance of interns. And I can say that this is true not only for defense teams, not only for legal representatives teams, but also for the court itself. The court is heavily relying on its interns to perform functions which are require the level of qualification that they have. That's an excellent opportunity for them if they can afford, unfortunately, and that's something that is extremely necessary to the daily work of the court. So yeah, the court is lucky, and we defense teams are lucky to still have the capacity to attract new candidates for internships. I hope this will carry on like this, even though, as Ahmed said, the conditions should improve.
Hopefully, they will. Apologies, I just 1 second. I'm having an issue with my camera.
Maybe we can start with the next question again, or? Yes,
my next question. I'll start with Counsel Lauchi. It's my last question, honestly, an advice for the students and for the researchers.
That's a very good one. I could speak for hours on that too. Well, my response will be primarily oriented towards the students in law. I mean, people with a legal qualification, legal background. The international criminal justice is a very fascinating field and domain. A lot to achieve. It's a domain that is permanently developing, and we are still building the thing. It's not because the court was created in 1998 that the history is over. Far from it. We can see on a daily basis new development in the case law of the court, and we can also see needs for very significant developments, which I hope will come one day. I mentioned the reparations one, but there are many others. So for this, I would say I can encourage students and whoever is interested in law to pay attention to international criminal justice, and if they are interested, to try to join it and support it. It can be supported from inside as a staff member. It can be supported from outside as workers in non-governmental organizations or association or whatever. There are many ways to contribute to international criminal justice. Now, this is just the invitation for those of you who are already motivated. There was no need for that. For those who are already motivated, I would say this. I will talk about my personal experience, actually. I studied in the first years of my career. I was essentially an academic. I was lecturing in my university and lecturing in the relevant fields, that is international humanitarian law, international criminal law, all that sort of things. And in the meantime, while drafting my PhD, I was also applying for, by the time it was the ICTY, the former Yugoslavia Tribunal, and the Rwanda Tribunal. And, well, my applications never, I was never selected for any interview, whatever, anything. And I completed my PhD, okay, and then I had to find a job, so I did the qualification to become a lawyer, a counsel, an avocat in my country. And then I completed that. It was easy after the PhD. And I started working as a lawyer in domestic courts, like doing usual things, criminal law, but and also administrative law, all sorts of things. And within less than 1 year, I was appointed in the ICTR with my first job as associate legal officer for the chambers in the Tribunal for Rwanda. What was the difference? The difference is that I had become a lawyer. And one day, when I was in Arusha, I asked to my main supervisor, the head of chambers, actually, say, I have applied for years. You never interviewed me, and now suddenly you do it. What is the change? Say, well, we have seen, Cyril, your application for quite a long time. We were interested, but we were a little bit reluctant because you were only an academic without practical experience. And for that, we were a little bit frightened. Actually, beyond this anecdote, I would say that, like it or not, in law, you need to be qualified as a lawyer to be fully considered as, well, so do your bar. That's my advice. It's important. It's a very relevant experience. You will learn from it, even though the work before domestic courts is sometimes extremely difficult, and it's not an easy job, but it's a one that is where you will really learn from it and then apply, of course, and one day it will work. But you never know when it will work. It could take years. In the meantime, you need to do something else, and by the time, your profile will actually increase because you will have experience.
So your advice, Counsel Lauchi, is become a lawyer.
I think it's in law, it's an essential step. Yes.
Uh-huh. So practical experience is very necessary in any field you want to work in.
The practical experience, if you do not become a lawyer, the other way of getting a practical experience is what we talked about earlier. That's the internship. But as we mentioned, it's a costful one. Not everybody can afford it. And yes, it's a first or experience. You can do that several times if you do it before different institutions, but it's not yet a job. The job you need to get it. Internship can be useful for that. But yeah, I think these are the two main ways of getting considered by these organizations. Either you qualify as a lawyer and you carry on. Of course, I mean, if you have, in addition to that, a strong academic background, if you write publications, if you make yourself known for whatever reasons, that's, of course, even better. But become a lawyer or go through internship. These are the two main entries to these organizations, I believe.
How about you, Ahmed? What do you advise students and researchers?
Absolutely. The fact of putting practice, the knowledge you've gained into practice is fundamental. Becoming a lawyer would be ideal. As Counsel Lauchi mentioned, working in a law firm would give you a lot of knowledge, a lot of different perspectives. I'm not talking strictly international criminal law. It would give you knowledge in many different fields, which would give you also a different legal perspective. Obviously, like anything you will do, maximum effort, create as much experience as you can. Also, if you're not sure which field of law you're interested in, try to go outside the box and explore different opportunities. An internship would be ideal to do that. Exploring different opportunities may give you the chance of finding yourself in a certain field. And if you already have an interest in a particular field and you're not lost, you're just know what you want, which field of law do you like me, I personally like criminal law in general, then follow that interest and give it your 110%, not everything you can, plus extra effort in order to push yourself, push your limits. That's what matters at the end of the day. That's what will be seen. And I have personally started in this field by following my interest. Today, international criminal law became a passion, and it was the light I followed throughout my path. So also thank you, Nazem, and for your team for creating your initiative and sharing this light within the field of international human rights, because it is a very important. I come from a place where there's almost nearly not enough awareness to the subject of international human rights. These topics, awareness is super important, and I believe that something like your initiative could put the light on this and push people to actually have the curiosity of exploring it and taking opportunity that could change their life as it changed mine.
Thank you so much, Ahmed. Thank you, Council Lauchi. Thank you for this fruitful discussion, for this tremendous knowledge, for exciting information you provided us with. Also, I would like to mention for the audience that we have a virtual visit for the ICC next month, and
Lucky, nobody can enter it correctly.
We will be posting applications by the end of this month. I would like to thank you again, Council Cyril Lauchi, Mr. Ahmed Isa. Thank you a lot, and we hope to see you again with us in another sessions and another discussions. Thank you so much, and have a very nice and good evening.
You are very welcome. It was a pleasure to participate, and thank you for the attention of the audience.
Thank you very much, Nazem, and for your team and everything. It was a pleasure.
Thank you for your audience, and have a nice evening. Bye.
Thank you. Bye-bye.